All right. Welcome, everybody, to the RAS Step Up Your Safety webinar series. I am Therese, your moderator for the day. We actually have some claim staff with us. They'll introduce themselves in a minute. They are going to be covering some of the questions that have come in from you as I sent out emails requesting some information on questions you had about claims and things and how they happen and how it works. So we're going to let them introduce themselves. Then I will start ask the question that came in and they'll answer it. If you want to use the Q&A feature, feel free to do that. We will get to those at the end if we can. If we can't get to your question at the end, you may want to email myself or leave your name with your question, and we will then get back to you either out of the claims department or somebody will for what your question is. So I am going to go ahead and let you get started. Sarah, if you would like to start, and we'll just do, you guys can introduce yourselves and we'll go
Okay.
from there.
Okay. I'm Sarah Mitchell. I've been with RAS for about right at 12 years now. Um, and I handle mainly Missouri, Kansas, some Nebraska, and I reside about an hour south of Kansas City.
Amanda?
Hi, everybody. My name is Amanda Volp. I've been with RAS just a little over a year and a half, but I've been handling work comp claims for about 20 years. Currently, I handle Minnesota, Wisconsin, and Iowa.
Lorna?
Hi, my name's Lorna Chambers. I have been at RAS 4 years on Saturday, so it's my big anniversary coming up. I have been working in this field for over 30 years. I've pretty much done anything in the Midwest, including North Dakota stopgap, as well as Indiana, Kentucky. But mostly right now I do Minnesota and South Dakota. So.
And Elvira?
Hi, my name is Elvira Vargas. I've been with RAS coming up for my first year. I've been in workers' comp for the past 7 years, specifically working mostly Nevada, Utah, Colorado, and I've gone ahead and also ventured into California. So definitely staying more on the east side. And as far as it goes for workers' comp, always looking to go ahead and give a little bit of insight, working with different entities. So as far as it goes, some of those employers can definitely give a little bit more information when it comes to that. So definitely a little bit of background in different fields when it comes to it.
Thank you. All right. The biggest question that came in is communication. I think I had it 5 different times from different companies asking from communication guidelines, communication with employers, carrier, the injured worker. Um, Anything that you can give us on communication would be great. And I know one of you wanted to take this.
Oh, yeah, I jumped at it. Right. Okay, so as far as communication goes, like right off the get-go, if we get a new claim or a reassign, so if a lower level adjuster has a claim and the person, needs surgery, starts losing time, it'll get bumped up, get reassigned. So we have 24 hours to make contact with the employer, the injured worker, and also the provider's office. So that's the 24-hour contact on a new one. As far as ongoing communication, I mean, communication is probably one of the biggest things we do. Um, so what we're going to do is keep in contact with the employee after every appointment, see how the appointment went. If there's anything ordered, we can get that approved for them. Contact the employer as well. And I mean, we can call. We actually have text availability too now, so we can do that or email. But get the work status to the employer. Make sure that everybody knows, what exactly is going on, what the plan is, and then as far as the providers, just following up for those medical reports and work status after every appointment, and making sure that if there's therapy that needs approved or there's, MRI or some type of diagnostics that we're getting that taken care of as well. So I know then one of the questions was, as an employer, and this is the way I read it anyway, what can we say or should we say to our injured worker? And I know sometimes I've had claims in which the employee goes to the employer for everything and they're asking questions that the employer really doesn't have the answer to. So then the employer reaches out and like, so and so came to me, this, that, whatever. So a lot of the times in those cases, I'll just tell them, just tell them if they have questions, contact me directly or I'll contact them. Like you don't need to be a go-between unless you want to be. And then, of course, there's times when you have injured workers that are off work. And one of the issues I see, it seems like more often than you would think, is that the employees off work, they're not keeping tabs or keeping in contact with their employer as far as their work status and stuff like that. But on the flip side, you get a hold of the employer and they're like, I haven't talked to them. I'm like, well, have you reached out to them? So people, when they're off work, it's really good that the employer is reaching out to them to make sure that, they know that they care about them, that they want them back to work, and all that good stuff. But obviously, the more communication, the better from all parties. But the things what you can say or should say to them is, I would say, keep it strictly related to the injury, to the work status, their accommodations, what do they need, all that good stuff. Especially if it becomes litigated, then that's even more of an issue. Like you don't want to get into things other, as far as their behavior, or you just want to keep it pretty strict to the claim itself, to the work status, the restrictions, next appointment, stuff like that. And then if you have any concerns or questions about it, always, reach out to your adjuster at that point. We can try and help or get an answer for you.
If it's okay, Sarah, I'd like to just add that
Sure.
when you have like nurses, or like in Minnesota there are QRCs, or or there's attorneys involved, just remember that anything you say to any of those people, like if you say something to the employee, if you say something to the nurse, if you say something to the rehab provider, two things. One, most of them are required, the vendors are required to put your communication into their report. So, you don't want to say anything to any of these people that you don't want the employee and their attorney to know. And so a lot of times when a case is litigated, we have to be careful of who all we're copying in on things, and being careful about, well, I know and we do too. We want to let everybody know kind of what's going on, but it's a little bit of a need to know thing. Like, does everybody, down to their supervisor who might not know anything really about the claim process, need to be copied in on every email? Probably not. So I think, when you're talking about when things get a little more complex, or if there's litigation, you do need to be more careful. And again, I'm not saying you can't include an employee or you can't include a nurse, but just be aware that they're going to share that information with both the plaintiff and the defense attorney, because that's their requirement. They're not there to weed out what we should not have said.
And then I know, adding to that question, it says here, as far as when they defer questions about bills they might receive, like an injured worker, should they refer the injured worker to us, or them take care of it and send it to us? And honestly, that's your preference. I mean, as far as the employer goes, if they come to you with a bill or whatever, if you want to tell them to send it to me or get a hold of me, I can call them. I mean, you can fax it or email it in. It's just whatever works. A lot of injured workers, sometimes they get bills in the mail because the insurance wasn't, set up properly. So they receive a statement. And to tell you the truth, I normally tell them just take a picture of it, text it to me. And that seems to be the easiest, quickest way to address that. So I think we pretty well covered communication.
Excellent. Thank you. Next question is about complex claims, specifically questions about return to work. And Elvira, do you want to, you have that one, correct?
Yes.
All
So
right.
going a little bit over, there's quite a bit of different components between this one, but will really depend on who's involved. For the most part, examiners are the ones that take the lead with sending letters to the doctors on asking the reason for specific restrictions. Is more so if they seem to be excessive, but even on a regular basis, we can send those out and ask questions. What is the expected time for this person to remain on those restrictions? What are the concerns, and what's the plan for the progress? In some cases where there is a nurse case manager, they can also assist with either drafting those letters or even walking the letter that the examiner wrote up to the doctor and make sure that we're getting a response as soon as possible. Also, if there is a position that's available, we want to go ahead and send that to the physician to sign off in the cases where it seems that this person could potentially return to work at some level. For example, let's say we have a person that's very has very physically demanding jobs, such as a roofer. In some situations, we see the doctors just place them completely off of work with the concern that they're going to be returning into that same position. When we work with the employers and ask the question, perhaps, do you have an office job? Would they be able to be helping with cleaning? Anything that maybe is a little bit less physically demanding, we can send to the physician and see, would you agree that this is something they are physically able to do? Definitely, it will vary with every jurisdiction as far as the people that need to be copied, if that is an actual requirement, or if that would give any implications also to terminate any additional benefits that are being paid to the injured worker. But it also gets us a better idea of what exactly is going on with the person. I know the question also mentioned in some cases that we see employees go back to the doctors to get additional work restrictions because they didn't like the light duty position that was offered. When that happens, one of the things that we also do is once again collaborate with the doctor if the nurse case manager is assigned to the claim and ask the question, has there been any physical change since the last time the person was evaluated? If that's the case, perhaps there will be more information we need to gather. Did they maybe fall? Was there something non-industrial that happened during that time that now is preventing them from returning to the position that was initially okayed or that they were initially deemed capable of doing? So definitely asking those additional questions will be the biggest part of it. We do have some additional return to work programs that are alternative after we've examined if there's anything that could potentially be done within the company the employee works for. But every situation is a little bit different given where the person resides, given what they earn, and also the length of which we expect them to be holding that position. But it is something we're actively working on and always updating the employer, even when they are back to work at a light duty capacity, since those restrictions may start to become less with every visit and as they progress with their treatment. We want to make sure that they're on the right path to return to full duty rather than having a completely different job and then having that difficulty to go back to work one day from another.
Awesome. Thank you. The next one I have is employer liability. And this one is a little specific. It's relates, like, for example, in South Dakota law, that employee must report a work injury within 3 business days. Why do claims still get covered if an employee didn't notify anyone for months? What makes a claim deniable for failure to report timely?
Okay, then. Um, this is, this is addressed in South Dakota, but most states have a reporting guideline, and sometimes the reporting guideline can lead you to what would be considered a soft denial versus a more hard denial, where some states really like ban reporting after a certain amount of time. In South Dakota, the timeline is within 3 days. I think, if it's a traumatic injury, I fell and I broke my leg, or I got my finger caught in a machine, I think those are a lot easier to identify and say, okay, they need to be reported. Sometimes when we have injuries that are more insidious or repetitive or are an occupational sort of exposure, it gets a little harder to know when the 3 days start. And there's some case law in all states about that. But the other thing is, in most states, having more to deny based on than just reporting is always a good thing. I think in South Dakota, it's actually easier than a lot of states to deny based solely on reporting, because they have a more firm guideline and they've held that in place, with the courts. But each case always has to be reviewed within its specific pieces. So, that's the challenge of work comp is as much as we think the law is black and white, I spend most of my day swimming around in the gray. And, so is it possible to deny a case just based on reporting in South Dakota or in other states? Yes. But if you have a cumulative injury where it's not as clear to when did they know it was a work-related injury, the other thing is, who did they tell? Because it might not have been that they told the HR person or the employee health person. They could have told their supervisor, which in most employers' worlds would be considered timely reporting. Now, if the supervisor doesn't tell anyone, that then becomes the problem. Or if it takes them a week to tell somebody in HR or whoever files the first report, so I think one thing is to make sure that any of your frontline supervisors understand whatever the reporting requirements are in the jurisdictions you work in. And, know that if someone approaches them and says, "Hey, I have a work injury report," it's not about whether the injury is payable or not. That's what we do. You simply fill out the form so we can set up a claim file. That's what the first report of injury is. It's not a admission of liability. And so the sooner we can get all those papers working forward, then the sooner our defenses can fall into place, and hopefully, we can use late reporting appropriately in the states that it works in. But is it going to work every time? No, denial really works every time in every jurisdiction, unfortunately. So I hope that helped.
Thank you. Medication costs. So if an employee, physician's doctor office, eye doctor, dentist office, things like that, has a claim, can the office cover the cost of medication versus having the treatment run through work comp? They would still file a claim. However, they could utilize the med samples they have versus having work comp pay for them.
Again, as a work comp adjuster, having done this for a long time, my initial response is please don't, but I can understand why it might work in certain cases. Here's where we run into problems is if it's, in the ideal world, they have some sort of minor injury, you give them a 5-day pack of whatever antibiotics or, whatever you have available that you think is appropriate as a medical provider. And they get better and everything's fine. Here comes the challenge is 2 months later now they're saying, well, I'm still having this problem. And yeah, we have a first report, we have a claim set up as an incident only, but what sort of documentation do we have as far as what you did in your office? Because and I work with a lot of hospitals and I've worked with a lot of clinics and medical providers before. And again, in reality, I think it can work very well for minor injuries. The challenge is always we don't know what's going to turn into a bigger injury. And so if you're documenting what you're doing and why, almost like a medical note, and some employee health services do this where they manage a lot of this internally until they really aren't able to anymore. They have nursing staff, they have providers that can provide prescriptions if they're needed. The documentation becomes a really important piece because if there's no documentation of that initial treatment, what was given, what their diagnosis is, to recreate that 2 or 3 or sometimes years later becomes very difficult. So even though we have a first report of injury, if nothing is coming through as work comp, then we don't have any record of what actually happened. And so it gets hard to know what should be payable and shouldn't be payable. Again, some places have a better controlled risk management team. I think it becomes harder when you're a smaller employer and you're the person who's doing work comp is wearing 10 different hats. But even in a medical provider's office, I think you just need to be careful. The other thing is if treatment is coming, and needing more, I mean, most states have a fee schedule in place so that at least we can usually pay less than what, would be charged under their health insurance. Um, so I don't think I can stop you from doing it. And there might be some cases where it's appropriate, but I think you just really have to document things well. And then because I'm going to ask for those records if they've been treating at your facility, even though they're an employee.
Thank you. Documenting and storage. So documenting, what are the best methods? Storage, length of storage, acceptable methods of documents for claims, video, witness reports, etc.
So, best methods for documenting an incident and injury, it's going to be to get the details in writing. So once you get a verbal notice, make sure you follow up, get something in writing, whether it be the first report of injury or you have some sort of internal report. Get as many details as you can, the time of the injury, where it took place, if there was any witnesses, all that kind of information. General work comp documentation should be kept for at least a minimum of the statute of limitations. OSHA probably has some other rules, so just kind of follow up with your state guidelines. But like I've heard medical reports such as physicals, injury reports, if you have any like toxic or hazardous exposures, that OSHA does require those for the duration of their employment plus 30 years. There's many methods of acceptable documentations. You can get written statements, video surveillance, witness reports. All of those things are acceptable. And then you should always keep the workers' compensation file separate from the employee's general files. Just make sure you're complying with privacy laws like HIPAA.
Okay. Lost time and appointments. How do people handle lost time when employees have appointments during their scheduled workday that are due to their work comp injury?
From the first day we make contact with employees, we let them know and encourage them to schedule treatment outside of their work hours, be it before or after work as much as possible, and to always communicate with their employer ahead of time when those appointments will be so they can plan accordingly. In most states and in most situations, the time that's taken to attend those appointments is not compensated by workers' comp. So, to also avoid any financial burden, we encourage them to talk with their employers, ask if there is a potential to either start the day earlier if they're going to leave an hour early for an appointment, make it up perhaps the next day, but always planning ahead of time. All of these facilities that we refer them to, for the most part, do have extended hours. So, as much as possible, they are able to go ahead and work with that. Also, at the time that they are seen for that appointment, they're given the next one. So, in many instances, they already have the next appointment for the following week or following month to go ahead and make the arrangements. So, really, communication is always the biggest thing that we mention with that. Um, Always encouraging for it to start from the employee side, since they're the ones that would be sending over those notes. But at the same time, the employers are also able to go ahead and communicate when they are being notified, for example, by the examiner, hey, this person will be having this appointment, more so when there might be evaluations that could take most of their day. Then at that point can go ahead and communicate with the employee, see, are you planning to just take off completely that day? Would there be hours to be made up later on, or so on? But always making sure that there isn't any no-show cases. They are always supposed to continue to abide by any employee guidelines already stipulated when it comes to any time away from work.
Okay. So it is 12:23, and I have one more question that was kind of one of those late stragglers, and we'll see if anybody wants to answer it. But if you have anything else you can answer or put it in a question in our Q&A, and I'll be able to see it and ask the team. And again, feel free to go ahead and do that. But the one that we had that we'll just kind of fill in and see where this goes is they wanted some information on claims handling best practices, which is about as broad as you can get.
Yeah, well, and I can address some. I mean, obviously, RAS has its best practices, and we are educated on what those are as far as, and I think, like Sarah said earlier, I mean, one of the biggest ones is always our ability to communicate appropriately with everyone. And and again, just like a lot of things relative to a claim, the level or the timing of communication is probably more often when someone is off of work than when they're, at work and kind of just following up to get released from care. Best practices also addresses things that are probably statutorily needed, which is like when do you need to make payments? When do you need to make comments? How do you get information from providers? As well as just what we do internally as far as you know, uh, in the claim file, setting up a plan of action, having a goal and a plan on what you're going to do over this next amount of time, as well as, accurately reserving the file so that we have a reflection of what the most likely exposure is going to be. Um, all the way down to when is it appropriate to close a claim? How do we manage our vendors that we utilize, whether that's legal or nurse case manager or any number of vendors that we might come into contact with. So I don't know if there's something more specific that you want. And then, our files are reviewed by our supervisor staff. Our files are also audited internally by an auditor that's their job. They're not, they don't do claim work anymore. They do claim auditing, as well as sometimes, depending on the state, we're audited by outside groups. If an employer is self-insured, sometimes they have their own auditing process that they go through. So there's a lot of people looking at files any way you slice it. I'm hopeful that gave them some answers, but it's a big topic. I mean, we could do a week of we could surely do a full day seminar on all the different little pieces of best practice within the claim handling world.
Thank you. I had a question that is, can the website take the videos rather than having to wait for a claim rep? It cannot. Website those videos are huge, and that's what people don't realize. And so we have to go through with the claims staff to work with them to get those videos back. But I do hear a lot that claims likes the videos. That can be very helpful. And so please make sure if you've got something on camera, even if it's minor, turn that into claims. Am I right, team?
And or save it. Be
Yeah.
sure you save it. And again, that's more of a statute of limitation things as far as how long you need to save it. For example, in Minnesota, after the first report is filed, they have 6 years before they can file a petition. So if that video is critical to compensability or the mechanism of injury, you need to save it for 6 years in Minnesota. Other states are going to have different statute of limitations.
You'd rather have a video you don't need than to not have one at all, right?
Yeah.
Yep.
And even if I can add to that too, in some situations, it's proven helpful not only if you have video of when the accident happened, but anything before and after. In some situations, unfortunately, maybe the camera did not catch exactly what happened, but if the person was seen with the same complaints coming into work than before the alleged accident happened, it's a big point. Also, the severity, what happened after even for late reporting can also strengthen those denials if needed or support an acceptance if needed.
Good point.
Thank you. And the one last one before I think we're going to have to close it. Do you have a template or some type of communication that we can send to providers inviting them to work site? Oh, inviting them to the work site for them to set the type of work that we can do and the type of light duty we can offer, because employers are not always honest about the work that they can perform. Employees are not always honest about the work that they can perform. I'm not sure if you guys have that, but Tanya might for return to work. Do you guys know?
Well, one good thing is to have a job description available of what that person does. And if you don't have a formal job description, because providing that to the employer is written proof of this is what this person does who has this job. There's a lot of ways we can get information to a provider about what they do. If it's really needed, we can videotape their work, what they do. We can have a nurse go, so in some jurisdictions, you could have a medical nurse or a QRC go out and do an evaluation of the work. The other thing, is if the doctor's having problems, writing work restrictions that you can follow, another way is to list out the things you have available. and send that to the doctor. So, they're going to be rolling silverware. The silverware weighs less than 1 pound, and if you bring people back to similar modified duty situations, and then the doctor can either approve or not approve that specific task. So even if they don't approve every task, if you have a list of 10 things and they say yes to 8 of them, then you can still bring them back. I mean, doctors used to go out and do this sort of thing. I don't know that many of them still do. Possibly occupational health providers would be willing to do that or look at video of, especially if you're having injuries in the kind of the same area or with the same piece of equipment. But the job description, and I think a lot of people also include a physical abilities form as well, which is good because it gives specific weights and times and limits of what they're going to be doing. So those are very helpful to send to the provider. And we can do that for you, definitely with a letter. Or, at the first visit, I think it's a little overwhelming to send everything to that provider. And sometimes we're really gonna need to use that at a different level provider than someone in urgent care. So, Elvira, anything you want to add?
Yes, I wanted to add in some situations, like you mentioned, we can do video and photographs. Definitely, I haven't been able to get a provider out even when requested, but I've been able to get the job to them in the sense of getting photographs, videos, and sending that over to them. Also, reminding ourselves that the physicians aren't necessarily assessing what they're only addressing what they're physically able to do. It's our job to find a position that meets the requirements. And a perfect example would be if the provider says this person can only sit for 4 hours at a time, we can have them doing anything from receptionist work to, like you said, rolling up any silverware, if they're able to do any filing and so on. But that would always depend on first what's available with your specific industry, your specific company, and then if there isn't anything there, can we explore those alternative programs? Also, in some cases where there is even a concern for further injury when there is a return to work, there is job site assessments that can be completed, and there's specialists we can refer for that. And at that point, we also now have a third party that is doing an evaluation and sending it over to the physician to make sure there isn't anything there. So sometimes when claims do continue to get complicated, we can do that. Or also if we're having maybe an employee that's continuing to file claims for similar situations, maybe there's something that can be done. And at that point, there'll probably be some upcoming safety training for not only that employee, but even everyone in that company or similar position as well to avoid any further injuries.
Excellent. Thank you, guys. That's it for today. We're just a couple minutes over, but as a reminder for those of you that have stuck this out, you will have a survey that will pop up at the end of this. And if you want to rewatch or share the video, this will also end up on our YouTube page. I will also send an email out with a link for you guys to have access to that before the end of the week. Thank you for attending and thank you for being our partner. Enjoy.